Good afternoon, Judge.
Good afternoon.
Your Honors, Evan Wright on behalf of the appellant, Mr. Ronnie Clayborn. I'd like to reserve 5 minutes of my time for rebuttal, please.
All right.
Your Honors, we're here today raising a single issue in this appeal and asking this court to grant Mr. Clayborn a new trial and reverse the trial court's denial of his post-conviction relief petition because the jury foreperson in this case failed to disclose his history as a law enforcement officer for the prosecuting agency, along with his prior relationships with some of the law enforcement witnesses. And as this panel knows, the Tennessee Constitution guarantees every accused a trial by a jury free of disqualification on account of some bias or partiality toward one side or the other of the litigation. Effective voir dire in any trial allows for the impaneling of this fair and impartial jury through questions that allow the trial counsel to make an intelligent exercise of their challenges. The Tennessee Code also says that a criminal defendant has, quote, an absolute right to examine prospective jurors. Our courts throughout the years have held, civil and criminal, that there's a great importance of the voir dire process, and they've zealously guarded it through decisions, especially in this court. So since full knowledge of the facts about a juror's qualification is so essential to the intelligent exercise of challenges, jurors are obligated to make a full and truthful answer. The court has directed them to neither answer falsely or concealing any material fact that would be responsive to a question that's asked in voir dire. The integrity of this process depends on the venire, the entire pool, giving a free and full response to questions that are posed by counsel. When jurors fail to disclose relevant and potentially prejudicial information, then the ability of trial counsel to make intelligent challenges and properly select a jury, ensuring due process, is going to be undermined. In this case, we're talking about what the courts refer to as a propter defectum, meaning that the defect in the juror is not based on some technicality like where they live or whether they're the proper age or that sort of thing. We're talking about possible bias. So when a juror conceals or fails to disclose relevant material information, in Tennessee we have a presumption of prejudice that arises. The failure to disclose this information when there's a material fact that from a question that is reasonably calculated to produce a particular answer gives rise to this presumption of bias, not just the partiality here, but that the juror has as they refer to it, a presence in the mind that will probably influence the judgment. That's the language I believe that's been used in Durham and some of the other cases. In Durham v. State, a juror was asked about his previous, quote, court experience that failed to reveal that he was a prosecuting witness in a similar case, and the Tennessee Supreme Court reversed that conviction and said, quote, does there not arise on the facts above shown a legal presumption of the want of the impartiality which our constitutional requirement contemplates? In Hyatt v. State, a juror had previously received a search warrant for the defendant's residence. The juror didn't realize because of the nickname of the defendant that the person sitting there in the voir dire was someone that he was familiar with, but he never disclosed it. And so the fact that he didn't disclose that he knew this person, the case was reversed, and the court said it must be presumed that the juror's prejudice is entered into and become part of the result. This court, in the Akins case that we've cited, and I believe the state discusses in its brief, really emphasized this point, and it said that from a practical standpoint, unless there is some assurance that jurors will respond fully and completely to questions put to the panel as a whole, the right to exercise challenges will be chilled. Attorneys will elect to pursue individual questioning of each potential juror at great loss of time to the courts and great expense to the public and the parties. We must demand of all participants in the justice system appropriate candor and conduct if the system itself is to maintain a position of dignity and respect. And that's what we're here today asking this court to do,
is protect that mandate. And that was the case from 1993.
Well, these cases that you're citing, I'm wondering if the facts are similar to this case, in that, as I understand it, Mr. Watson was the foreperson in question here.
Correct.
Had been a dispatcher for the sheriff's department 15 years before this offense happened. Is that correct?
He had been a sheriff's deputy for full-time for a year and then part-time for 2 more years. He had been a dispatcher for 5 years. He had also been a jailer. And of course, all of these various jobs are all under that same department, the prosecuting agency. Now, it had been some time, Judge, I'll concede.
That's the number I'm getting at. All of that experience with the sheriff's department had happened 15 years before this offense. And a lot of the players involved in the investigation and the sheriff's department and so forth, he didn't even know who they were. Isn't that what we learned at the post-conviction hearing?
Well, he did admit in the hearing under direct examination that he knew the sheriff very well and worked with him while he worked at the sheriff's department, and that was, of course, the prosecuting agency on the case. He also admitted finally that he did know both Anthony Gunner and the other law enforcement witness, Jason Duncan.
Those were the law enforcement officers involved in the investigation of this homicide?
It was a
rape.
Child
I'm sorry,
rape, yeah.
rape of a child.
Jason Duncan was the lead detective on the case, and Anthony Gunner, I believe he testified at trial on a statement that the defendant had made to him when he was serving him with the indictment.
Okay.
But it was Jason Duncan's case, effectively, as the prosecutor.
In any event, the record will reflect there was a pretty good gap between the time he had worked for the Fentress County Sheriff's Department and the trial of this case.
There was a large passage of time, Judge, and I think that highlights what we're saying here is it's possible that perhaps this is the most unbiased juror that has ever sat on a panel.
Well, that's kind of what the post-conviction judge found, right? We have to base a decision on what the post-conviction judge determined. We don't go back and review it. We look at what the post-conviction, see where the record supports what the post-conviction judge found. And the judge found that he didn't feel like that there was anything that this juror had done or said that was in violation of his oath to tell the truth and respond appropriately to questions asked of him, didn't he? Isn't that what the post-conviction judge found?
Well, Your Honor, the post-conviction judge said that the defendant had not met his burden of production for the presumption to arise.
Right.
But what we're arguing and what we've argued in our brief is that we did meet the presumption for the...
In other words, the post-conviction judge got that part wrong.
Correct.
Okay. Let me ask a couple... Well, follow up on what Judge Easter was asking too. Was this particular witness ever directly asked when he was in the box about prior employment?
He was never asked about prior employment directly to him.
Okay.
That of course, is why we highlight the language from the Akins case that says the veneer. When I'm picking a jury and I hear a question that's asked to the jury that's sitting here, maybe there's a whole room full of people, then...
So you may have asked that in the first 12 or 15, however you do it in the box. You may have asked at that point in time, or asked if they worked with law enforcement or something like that. And then when he ultimately came into the box, he was expected to know the answer to that question and to say something?
Well, so the most direct question on point here is that and I believe it was the prosecutor, asked if they knew any of the law enforcement witnesses.
And that was
this was before Watson was called into the box.
Okay.
And then when Watson was called into the box, it was said a couple of different ways. Does anyone want to express without me going through all the questioning that you've already heard? Was there anything in your background that would cause you reservation about sitting on the panel? And then later they were asked to reveal any relevant information. And I do believe that Mr. Fry at some point asked them, you've heard the questions that have been asked. Is there anything that has been asked that you would want to clarify? And that was after Mr. Watson was up.
So obviously this was a serious case, and I assume voir dire took a period of time.
I assume so, Judge. Of course,
Okay.
it's, reading it in the record.
But do you know how many
it's hard.
pages there were between the beginning and when this juror was actually called to the box? Like an hour, 2 hours?
He was called toward the end of 1 hour. I feel like I'm speculating a little bit there, but I believe I'm right that he was called toward the end of
Okay.
the voir dire process.
All right. So obviously he was as far as we know, he was in the courtroom while the questions are going on, but I mean, he wasn't then generally asked specifically about those questions. He was expected to remember what was said at the beginning, so to speak.
That was the expectation, and that's sort of the mandate in Aikens. He was asked specifically just to him about, it was a long question about the grand jury presentation and how it works, and that, only one side of the case is presented, and this is directly to him. And, he gives a one-word answer. He says yes. He never says, well, I've actually been in front of this exact same grand jury prosecuting a case for this exact same law enforcement agency. Now, the paragraph in the record right before this, it's laced with questions where there's no pause for the juror to actually answer. And our position is that he knew that some of this would indicate. He admitted that in the post-conviction hearing. I asked him, wouldn't you want to know if you were sitting here and someone asked these questions and I went through the questions, would you not want to know that you had been a sheriff's deputy for the Fentress County Sheriff's Department? And he said yes. And so he also indicates in the post-conviction hearing in some of his answers that he contemplated it while he was sitting there. Well, if he contemplated it, then raise your hand and say something and let the trial counsel decide, is it going to be an issue or is it not an issue? Or they can ask the follow-up questions. How long did you work with the sheriff? How well do you know Mr. Duncan? How well do you know Mr. Gunner? All of those things, it doesn't disqualify him, but that's not what the rule is. The court in Aikens emphasized that when questions are asked to the venire, it is the duty of the jurors to be able to, in full candor, disclose information that would be relevant to their service on the case. I think, just look at this from a different context. We're in a civil case. It's a car accident case. The allegedly at-fault person works for UPS, and you've got a juror sitting there that retired from UPS 10, 12 years ago. And they sit through this entire process and they never say a word, never raise their hand and say, well, I worked for some years for UPS until I retired. I think anyone who would be sitting at the plaintiff's table would think, surely that is something that juror, when we were asking about their background and we were asking about all of these various questions surrounding your life experience, that you would speak up and say, yeah, I used to work with the sheriff at the Fentress County Sheriff's Department and worked with him for several years. Yeah, I used to work in that jail. I mean, that's what we're saying. The two trial attorneys that tried this case, both very experienced attorneys, both of them testified at the post-conviction hearing that they believed that the questions that they were asking were such that they would have generated at least a response that highlighted at least some, or at least brought that experience to the surface. The cases the state cites, Taylor and Pender, and of course, any of these cases are going to be somewhat fact-dependent, and it's hard to find a case that's exactly on point. Taylor was a question about any close friends in law enforcement. The Pender case, it involved an officer who wasn't working for the prosecuting agency. These cases are also much older than the Aikens case. These are the cases from the early 80s. But I think really the whole case turns, and what the court's opinion here will turn on, the general nature of the questions. Were the questions specific enough? It was the whole argument that was made at the post-conviction hearing. It's the argument that's been made on the briefs now. And what we're asking the court really to do here today is to look back at the language of Aikens in the spirit of that rule and highlight that today, that we're going to say, okay, we need jurors to feel like they should speak up. If you hear something that's even remotely possibly indicates that you need to reveal that and you need to speak up and say, okay, yes, I had this experience. Yes, I used to work here. Yes, I'm affiliated with this person in some way. It's not condemning this gentleman at all. It's just simply saying that Mr. Clayborn's trial counsel, in order to receive the process that he's due, must know these facts.
But even under Akins, doesn't the court require that the conduct of the potential juror or the juror is willful? Isn't there that there's some requirement that it has to be a willful act, that the juror willfully was dishonest or withheld?
That's the language, but there's a presumption that they are willful, and then there's language that says that they can't scrub out the presumption by simply saying, oh no, I'm not biased. And that's, effectively what we got in the post-conviction hearing. If you look at the transcript, he changed his story multiple times during the post-conviction hearing. I believe my time has expired.
Thank you, counsel. Thank you.
Good afternoon. May it please the court, Your Honors. Ben Ball on behalf of the state. The defendant, the petitioner here referenced earlier, this would really come down to the generalness versus specificness of the questions here. And I tend to agree with him on that. And I would note for this court that in his brief and during his argument, my friend on the other side didn't really discuss very much the specific questions asked here of the venire. And I think that's important, because it's clear here that the venire was not asked, have you ever been employed by law enforcement? The questions that would have elicited the responses that the defense counsel indicated that he would have liked to receive just were not asked here. I agree that defense counsel probably would have liked to have known if anyone in the venire had been in law enforcement. Defense counsel did not ask that question. Petitioners identified 7 questions, or at least citations to where they were asked. Often doesn't specify what questions, and I think for understandable reasons here. The first of these, he indicates that they were asked about prior dealings with Fentress County Sheriff's Department. It's a long question, and I hate reading for the court, but I think it's important in these questions. What was asked was, is there anything about your experience in general with law enforcement or with the court system that would and then there's some stumbling over words that you would have to say, let's face it, we're here in 2020, and we watch TV, and we listen to the news and all that kind of stuff. And this is, of course, in 2020 when George Floyd, the riots and things of that nature were going on. And there's people that just flat out do not like police. Doesn't matter if you know them or not, doesn't matter if you've ever seen them or not, there's people just hate police. Would you be honest enough to tell me if you feel that way? Anybody just have a total disregard for any law enforcement officer? Mr. Watson reasonably understood this as a question of whether he had a problem with law enforcement, not whether he had ever been a member of law enforcement, and that was a reasonable interpretation of that question. This was a question about the climate that summer with some public perception of anti-law enforcement sentiment. It was not asked if he'd been in law enforcement. The big question petitioner points to was the venire was generally asked if they knew officers Duncan or Gunter. And at the post-conviction hearing, what Mr. Watson says is essentially, I knew of them, I didn't know them. So when I answered, I didn't feel a responsibility to say that I knew them. One of them he had no real encounters with. The other one he'd gone to high school with, a small area. But he said that he did not know that person, I believe it was Gunter, well enough to even form an opinion about whether he was truthful or not. So when he said he didn't know them, he didn't know them. And then he points to a exchange that took place, and this is another lengthy question, where he contends that he was asked if he understood different aspects of criminal trial process. This should have led him to volunteer that he had worked for the Sheriff's Department 15 years earlier. What he was asked was, Mr. Watson, just kind of talk about our system a little bit. When the state charges an individual, the defendant doesn't have the right to be there. He doesn't get the opportunity to present his side. This is the very first time that he gets to present his side and his evidence. And when you hear that a grand jury has charged somebody, well, I don't have the right to be there at a grand jury. I don't have the right to present any evidence, and I was not there. I wasn't present, and Mr. Ronnie Clayborn wasn't there. And if you understand that, if at break the state were to exit the room and we locked the doors, if they couldn't put on their side, who's going to win the trial? The defendant, because you would hear only one side of a version, you wouldn't hear the other. So can you put that out of your mind, that the aspect of, hey, a grand jury heard the case, but they didn't hear evidence from the defendant? And Mr. Watson answered, yes. So essentially he was asked, can you put out of your mind that a grand jury returned an indictment? Didn't ask, have you ever been involved with the grand jury? And he didn't ask, have you ever served in law enforcement? The next 4 questions, I've identified the 3 areas. He identifies 4 more citations. These are what I would call catch-all questions. These all come at the end of voir dire, and the questions are as follows. Is there anything I've asked here during this round or during the previous rounds that you, just to be completely open and honest and transparent, that you need a comment on? Again, not a question about whether he served in law enforcement. The other 3 are basically the same thing. I'm not going to read them all for you, but they were, anybody want to give a response to anything that's been asked this morning is one of those. Tell this court is that at no point Mr. Watson or anybody asked, were you a member of the Sheriff's Department? And as far as Officer Duncan and Gunter, he testified and didn't know them. Post-conviction hearing and the PC court accredited that. So the petitioner hasn't made a prima facie case here. He has not shown that Mr. Watson either answered a question dishonestly or should have been compelled to provide information based on another question. And so the post-conviction court properly denied this claim. And if there are no further questions, I would urge this court to affirm the judgment of the post-conviction court.
All right, thank you, General.
Thank you, Your Honors.
All right, rebuttal.
My time stretches a lot further when I only have one issue to argue about. So, Your Honors, the record shows in the PCR hearing what the juror perceived the questions to be, and the juror admitted in the PCR hearing that he thought that the questions about knowing the law enforcement officers were, this was how he sort of redirected the court, but he's got this all backwards. So he says, well, I thought they meant just knew of them. Well, he didn't answer that either. If he thought that the questions in to the veneer or in the voir dire process were just I knew of, well, he obviously knew of these people. It was a little more than that. He admitted in the post-conviction hearing that he had conversed with these witnesses before, that he knew them to speak to them. So it's a little bit disingenuous for him to say that, well, I just thought they were asking me if I knew of these people. It's a small community. I know of a lot of people. Well, if you thought that's what they meant, then why didn't you raise your hand and say, I know of them? He didn't say that. And he later admitted that he actually knew them, that he conversed with them on different occasions. The questions at the end about your background and your experience, they're general. I'll concede that. They're definitely, it's a tough ask of this court to read what the underlying intent of those was, but that's one reason that the trial counsel was asked that in the post-conviction hearing, is when you ask these general questions, in your experience, and I think Judge Fry now had said something to the effect that he had tried like 40 jury trials or somewhere along those lines, and that his intent was to find out, anybody had any interaction with the court system, because those are the sorts of things that certainly would change your perception of the process. And, to be asked a lengthy question about a grand jury process, how many people do you think serve on juries in this state that have actually presented a case to the grand jury and sit there and get asked about the grand jury process? And he never mentions, hey, I've done that. Well, if he's sitting in a medical malpractice case and they're talking to him about brain surgery and he's a neurosurgeon and he's sitting there, you think it's odd that they explain the process to him and he said, yeah, I spent like 15 years working at St. Thomas. You just expect somebody to say that. So what I think we do if we say, okay, these questions were not specific enough, even the question about do you know these people, when he certainly knew these people and he didn't allow trial counsel privilege of being able to assess how well he knew them. What we're saying to folks is, okay, it's okay, just sit there, and the lawyers just need to pepper you with questions and just be as specific as humanly possible to every single juror to make sure that they, you drive out every single avenue of bias. When the court's evaluating this case, I think it's worth looking back at the factual background of the case. It's a very, very weak case. The trial court, the original trial court judge, Judge Sexton, acknowledged that this case could have, quote, gone either way, I believe is what he said. So what we had is a case where we just had the accuser, the defendant, and we had one other person in the room that said it didn't happen, and we've got a conviction. We're asking this court to reverse the post-conviction court's ruling based on the lack of candor from this juror. If your honors have any more questions, I'm happy to answer those.
All right, thank you, Mr. Wright. Good
Thank you,
job.
Judge.
We'll get this case out in the next few weeks. All right, we're going to take a short recess, and we'll be back.
All right.